installment of Martial Law here on WCCS. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the data or the date and your particular legal problem. Each legal problem depends on its individual facts. Different jurisdictions have different laws and regulations, and because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. That would be, in this case, Marshall Chriswell. Good morning.
Good morning.
How are you?
I'm doing well. How are you this morning?
Terrific.
Good.
It's a beautiful morning today and kind of cold, but that's okay. All right. I want to talk a little bit about real estate and some do's and don'ts, maybe some tales that of incidents that you might have come across where somebody did something a little bit wrong and it ended up costing them or could have ended up costing them in a major way. So I'm sure that you have some sorts of those stories in your background in all of your dealings with real estate law, don't you?
I do, and one particularly recent scenario comes to mind. I have a client who, and this is against their better judgment and probably not, without any form of legal advice whatsoever. But what they did was they purchased, over a period of a few years, they purchased several adjacent properties, and these were recreational properties, hunting camp kind of properties. Mm-hmm. And so they purchased them, and whenever they bought them, 2 out of the 3 parcels that they bought, they actually placed not only in the names of the husband and wife that were buying them, but they put their minor children's names on the deed as grantees on the deed. So it actually vested a fractional ownership of this property in minor children. And at this time, the kids were 3, 4, 5 years old. Mm-hmm. They did this, like I said, probably without any kind of legal advice whatsoever. And what they thought, mistakenly was, well, this is a really good thing to do for planning purposes, estate planning purposes. If something happens to us, then our children are going to have the benefit of this property, and they're going to become the owners of it, and that's going to be beneficial for them, and it's going to reduce expenses as far as having associated with an estate and inheritance taxes and things like that, which it really would have done none of those things, but they didn't realize that at the time. So fast forward about 9-10 years now, the kids are still minors, and the parents have moved. They've moved out of state, and they say, well, we're not using this property. We're going to go ahead and sell it. And it's fairly valuable. It's a nice piece of ground, and so they pretty quickly get it under contract to sell, and they set a closing date, and all of a sudden, the buyer's attorney starts to do the title work and says, whoa, this is a problem, because kids that are under 18 can't, they can own property. Pennsylvania law says that they can own real estate, but they can't sign any kind of a contract or a deed because they don't have capacity. They're minors. So the clients are here 2 weeks from closing, and the buyer's attorney says, well, you can't convey to us good title, so we're not sure we want to buy this.
Yeah. Okay. Well, that is a thorny issue. How was it resolved?
So there are essentially only 2 ways that it can be resolved. 3. Number 1 is you can't sell the property. You've got to wait until the kids are of age, and then that they have a say in what you do with it. Mm-hmm. The other way to resolve it is to go through a court process. So you have to file a petition with the court to sell the property, and the court decides what happens with the proceeds. If the proceeds are under $25,000 per child, which thank goodness in this case they were, it ended up, once we calculated the child's fractional interest of the sale price, their share was just under $25,000. The court has the discretion to distribute those funds to the parents. Okay. You get a court order saying the parents have the right to sell the property and take the child's share and go ahead and do that. If it's over $25,000, the court has no discretion whatsoever. The court has to appoint a guardian to hold those funds at least until the child turns 18, and then the funds get turned over directly to the child. Which, of course, is not what the parents intended when they did this way back when. They of course thought that, hey, if we want to sell this property or do anything else with it, we're going to have the right to do that. We just put the kids' names on it for convenience and for planning purposes. Yeah. So, like I said, luckily in this case, they were under that $25,000 mark. But we still had to go through the process of filing a petition with the court. The judge can schedule a hearing. There goes a couple $1,000s of what the sale proceeds just to pay an attorney to do this stuff.
Mm-hmm. So, and it underscores the importance of having an attorney involved from the very start. If they had done that, they would have gotten the correct legal counsel and learned that that's not the way to go.
That's right. And no attorney would have advised them to place their minor children on the real estate without putting some form of a trust in place, a revocable, what we'd call a revocable trust, meaning that the parents still maintain complete control over the real estate, and if they want to sell it or they want to subdivide it or they want to mortgage it or place it in clean and green or do anything that you would do, be able to do as the owner of real estate, that the parents are still going to have the right to do that, because once you put another owner on the title, whether they're a minor or not, you lose control.
All right, so take us back to the very beginning of their thought processes and what they may have been when they decided to do that. Because a lot of people, I think, have this question. I have a piece of property, my home, or a campground, as you said, whatever this piece of property might be. When I'm gone, I want my child to have it, but I don't want my child to have to pay all these extra fees and taxes on it, and so I want to find some way to convey this property to them and avoid all of the extra burdens of taxes and other fees. So I don't know that that's possible, but you do. What should parents do in those cases to, as painlessly as possible, pass it on to their kids without having their kids get an enormous bill?
Sure. With minor children, I would encourage parents to use possibly a revocable trust deed. Okay, so we can actually deed the property in trust to the parents as trustees for the benefit of the children. Okay, so when the time comes that the parents are no longer here, there is a more seamless transition of the property being transferred to the kids. We can make them the beneficiaries of the property in your will. Okay, and then if they're minors, you still do need to have a trustee. In either one of those situations, we do need to have a trustee set up for what happens if the parents die and the kids are minors. But then you get to choose who that is, and you get to choose what the terms of that are, and so you can streamline the administration of it that way, so that you don't necessarily have to open a probate estate or have this property be administered through a probate estate, where potentially creditors and the like can get at it. Mm-hmm. So there are ways to do that. As far as taxes, unfortunately, inheritance taxes are going to apply to just about all succession plans. There are ways to avoid that, and I would probably wait until the kids are of age. Wait until they're adults, but you can transfer a fractional or a full ownership interest to the kids, when they get old enough to accept that. So you can, and that's something that we always talk about as part of an estate plan conversation, is, are there assets that we want to gift to children, to adult children, to take them out of your taxable estate? So, you start to have those conversations as the kids get older.
Mm-hmm. And obviously, everything that we've talked about this morning requires some really intricate knowledge of laws, and Certainly not something that you should try to do yourself, and certainly not something that you should say, okay, something on the internet must have something to do with that. I'll go find it and try it.
Oh, no, as we've discussed in the past, Todd, you wouldn't believe some of the messes that I have to clean up, that all attorneys have to clean up as a result of people trying to do these things themselves. The internet is a wonderful, wonderful tool that gives us access to all sorts of information, and there are lots of websites out there devoted to, hey, this is the easy way to do something legally, and you can never trust it because you don't know. Obviously, every factual situation is different, and if you're going to one of these websites that provides pre-printed forms or things like that, they're not taking into account what your particular situation is. And also you have jurisdictional issues. You get this information. These big companies that have websites that are available obviously everywhere in the world, but you could be looking at something that applies, only to California law or Florida law or Arizona law, and here we sit in Pennsylvania with a completely different set of laws. It's very dangerous to go online and just start printing forms and trying to achieve legal goals that way.
Yeah, well, that's what we say at the beginning of this segment each time, is different jurisdictions have different laws and regulations, and because of that, there are different ramifications, and certainly those are some of them. So somebody's sitting at home right now saying, okay, I'm approaching retirement age. In 5 or 10 years, I'll be there. I have kids who will be adults at that time. I need to, if I haven't done so already, I need to really get to work on this estate plan, which I know that you would heartily endorse. So what should they do in those cases?
Sure. You should contact my office, contact your attorney, set up a consultation. I know I do these consultations for no charge, where we can sit down and just have a discussion about, okay, what's your situation? What kinds of things do you own? How do you want them to be transferred? What's the ultimate goal with respect to the disposition of these assets, and how are we going to get there, and what makes the most sense? And the aim all the time is to streamline that process as much as possible, make it as easy as we can for the beneficiaries and the other folks that we're leaving behind, and save as much money as we can. It's that simple.
Very, very good. So in order to do that and set up that consultation, what do folks need to do?
You can give me a call at 724-465-5826. Come see me in the R&P Cole Building, which is 655 Church Street here in Indiana, or go online to www.westernpalawyer.com.
Very good. Marshall Chriswell, thanks for spending some time with us today.
Thanks, Todd. Have a great week.
You too. We'll see you.
Bye.
We'll see you.
Bye.
We'll see you.